Welcome everyone to the Asia Law Weekly. This is the program of NYU Law School's U.S. Asia Law Institute. I'm Catherine Wilhelm, Executive Director of the Institute, and today's topic is labor protections for overseas Chinese workers. Today, we have two speakers who are co-authors of a study about labor protections for overseas Chinese workers. If you haven't seen the study, it's available on our website, and we'll post the link in the chat panel. The first speaker is Xiaohui Ban, or Ban Xiaohui, who is an associate professor at Wuhan University Law School. He has a JSD from Wuhan University and has been a visiting scholar at the University of California in LA and a postdoc fellow at the University of Montreal Law School. And his research focuses on labor law and international labor law. And then with him is his co-author, Aaron Halegua, who is a lawyer in private practice, working also on labor law, both domestically and internationally. And he's a research fellow at our institute and at the NYU Law School Center for Labor and Employment Law. He recently assisted more than 2,000 Chinese construction workers who had been trafficked to Saipan to recover $14 million in back pay. And he's currently litigating a related case in US federal court to get compensation for injured workers who were injured on that project. He's consulted for Apple and the International Labor Rights Forum, Ford Foundation, the ILO, and others on labor issues in China, Thailand, Myanmar, and Mexico, and written many book chapters and so on this subject. Then moderating our session, we have Cynthia Esland, who's the Catherine A. Reen Professor of Law at NYU School of Law, where she teaches labor and employment law and workplace governance. Her current work is focusing on automation and the future of work, but in 2017, she wrote a book, A New Deal for China's Workers, ? That looks at labor unrest and reform in China. So with that, I'm going to hand the microphone over to her, and we can begin. Thanks everyone for being here.
Okay.
Thank you, everyone. Those of us who showed up early and those of you who are staying up late. We have a terrific group. Between our panelists, we have a wide range of experiences in representing Chinese workers in various contexts, as well as studying their situation. So I thought we would start by asking Xiaohui to give us a bit of an introduction to the problem that or the context that you're looking at in your co-authored paper.
Okay, thank you for inviting me to give such a speak. So let me sharing. Okay, thank you for inviting me to give such a speak. So this topic is very interesting. I also with Aaron. So the first part I will show about the brief introduction about the history of dispatching workers abroad. So China, we started from 1949 to 1970 years. As the first stage, the most government-sponsored development projects in the host country. For example, in 1970 years, the Chinese government sent more than 50,000 workers to Africa to construct the Zambia and the railway. And since 1979, Chinese government started the reform and the opening up policy. So the overseas labor market gradually forms. So from 1990, so we went into a very rapid development due to the expansion of the labor abroad channels and the relaxed action of the restriction on individuals going abroad for work. So as we see this chart, we can see that in 1984, there are only about 40,000 workers abroad. But when times come to 1990s, the curve increased very quickly. So one is reasons Chinese established the socialist economy, market economy, and another reason is that when time comes to nearly 2002, Chinese government just operated a go out strategy. A lot of Chinese investments go out, so with the increase of the abroad workers. But when time comes to the 20, you can see this chart. So when time comes to 2012, so the curve going increase very slowly, and with a downward trend. So what's the reasons? Because in 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 2013, China government just issued the Belton Road initiative. The government say when Chinese company go after to investments, they should operate locally. They had better to use the local workers to create more jobs for locals. And another reason you can see the chart from 2019 to 2020, they dropped dramatically because of COVID-19. So a lot of restriction for the overseas workers. So we move to the next chart. We can see, so for this chart, you can see the regional distribution of the overseas workers. So we can see the Asia and Africa, the workers most are concentrated in these two areas, including the Latin America, mostly in developing countries and underdeveloped countries. So let's move to next chart. You can see the top 10 countries. So the dispatched destination in 2019. So Japan, Singapore. So most Asia countries and Africa countries. If you go to see next picture, you can see the chart. Most workers are concentrated in construction and manufacturing and transportation, but in the high tech industry, there are a very small number of the workers. So there have been nearly 30 years for development of the dispatched overseas workers, but there have some common problems in the overseas labor market. You can see the first one is false information about jobs, because some employee just ensure false information about how good the worker overseas, maybe have higher salary and very good living conditions. And nextly, take security deposit from workers. Therefore, make sure they can easily to control the workers if they want to back to China. So also have some larger upfront recruitment fees from workers, because it's a way to make profits for the agency. So sometimes the employee also will use the tourist visa to trick worker to go abroad for working for the employer. So also they have some common problems, like just like the worker in domestic workers fail to pay wages and worker injuries. So sometimes employer also will confiscate the passport. I think Aaron will explain it in the 7 cases. So what happened for China government? So they do have some legal framework for the overseas workers. But if we see the labor law and the labor contract law, they have no anything about these issues of overseas workers. But we do have two administrative regulation from state council. The first type of worker is means overseas project contracting enterprise. This is a very important. It's a very important regulation. You can see that we have for this kind we have 2 models. One is we use the overseas project contract enterprise to sign a labor contract with the worker, then send to the foreign employer. Also, we will choose a foreign labor service corporation enterprise. Then we find the workers. Then we send to the foreign employers. But for both kinds of models, they should sign labor contract with the worker for the OPCE. And mostly, sometimes you will find the overseas subsidiary will contracting the project in the foreign country. So the regulation mostly about the first is that the OPCE should sign the labor contract with the worker, even they use the the Foreign Labor Service Corporation enterprise. So next, they're still responsible if they're subcontracted after work. That means that in some cases, when the OPEC the contract project, they will always to subcontract this project to another a smaller contractor. So it's always happened, but they still should be responsible if they subcontracted the work, because according to regulation, they should sign labor contract, so no security deposit may be collected. So they also will just, deposit the reserved fund just for the risk when they're handling risk that happened during the overseas works, just like they own to the payment. So they also, for the enterprise, they also must purchase the worker accident insurance for the workers. So for next model is a Foreign Labor Service Corporation enterprise. If you can see these two kind, they have two choices. First one, they sign a labor contract with the worker, then send to the foreign employee. Another way, they sign the service contract with the worker, then send to the foreign employee. And the Foreign Labor Service Corporation enterprise, they should have the worker to conclude a labor contract with a foreign employee. So for this kind of worker, we also have some special regulations. So at first, the Foreign Labor Service Corporation enterprise, they should they can only this kind of corporation enterprise that can recruit a Chinese worker. So for the Chinese employee, they cannot recruit a Chinese worker directly from China. And also they should have a registration. For this, they need about at least 6 million RMB for registered capital. And also they should verify the overseas employer and whether existence of the project. So for the Foreign Labor Service Corporation enterprise, they should conclude a written contract with the overseas employer. They should cover about 11 items such as position, social insurance, and blah blah. Also, they should deposit a reserve fund. This is same as the OPC. They should not less than RMB 3 million for handling risks. So we can see that if they have two choice, one is for labor contract and another is for service contract, but both they should liable for the workers if the workers cannot just like they cannot receive the benefits as the contractor agreed before, just like wages and also other things. So if also the workers just enjoyed, if the employee didn't purchase accident insurance, the Foreign Labor Service Corporation enterprise also should liable for the workers. So this is a basic legal framework for the overseas workers. Now I hand it to the Aaron. Okay.
Aaron, along the way, I'm hoping you're going to address one question I have already is, this looks like a pretty good legal framework. So take it away, Aaron.
Okay. So Xiaohui, if you could stop sharing your screen, I'm going to pull up a PowerPoint as well. But first, I'd just like to say thank you to the U.S. Asia Law Institute, which has been working on issues involving Chinese labor and Chinese workers since I got involved with them probably 7 or 8 years ago. Thank you to Cindy, who actually is the person who taught me my first employment law class when I was, I think, a 3L at Harvard many moons ago. And I think the U.S. Asia Law Institute in a lot of ways made this possible because if I remember correctly, the first time I met Xiaohui, and I believe Cindy met Xiaohui, was at a conference in Nanjing that we were doing about sexual harassment law in China and sort of labor relations and labor issues in China. So thank you for bringing us all together and on some level making this collaboration possible. So thank you to Xiaohui. I gave him the hard job of trying to explain, 60 years of Chinese labor migration history, as well as an overview of a somewhat complex regulatory scheme, all in 10 minutes and 5 or 6 slides. But I think the main takeaway is certainly you have this large number of Chinese going overseas, even if it's sort of tapered off in recent years. I think the absolute number is quite large. You have these problems that have persisted, right, about tricking workers and giving them false information and taking their security deposits and not getting paid when you're overseas, that we've been reading about for decades. So as Cindy mentioned, yeah, you have a pretty comprehensive system that says either you go through a licensed employer in China that sends you abroad and they have to comply with this, and this, or you go through an agency, which also is supposed to be registered and has to give you a contract that says this, and this. And so in practice, like the employment laws in many countries, it all sounds very coherent and comprehensive and a perfect system. But as we know, reality is often a bit messier. And so what I'm going to do is talk about a particular case that I've been working on that I think illustrates a lot of the problems that still persist, even despite this regulatory framework. So if I can figure this out, as I should be better at this now that we've been in pandemic mode for so many months. So is everyone able to see the PowerPoint? Yes, I see some nods. So I'm going to talk about a case in Saipan that Catherine had mentioned. I usually like to ask for a show of hands of how many people have heard of Saipan, but given the limitations of Zoom, I can't see the responses. And then the next question is usually, how many people can find it on a map, which is also challenging. But to simplify, well, just what you really need to know is that Saipan is a small island in the middle of the Pacific. It is a Commonwealth of the United States, so certain federal laws apply. Most of the US federal government enforcement agencies do have a presence there. And in this place, they had a sort of booming garment industry in the 90s for a bunch of reasons that I won't get into. That sort of died down, a lot of them relating to labor exploitation. They were searching for sort of a new economic driver, and what came along, one of the solutions was a Chinese invested casino had won the right to the exclusive gaming license for the island. So Imperial Pacific was the name of the casino. In order to build the actual structure, they hired at least 3 major Chinese firms to do the construction. One was a state-owned enterprise, MCC, another was called Gold Mantis, a third one was called Belton. As a sort of aside, since this is a crowd interested in China, I found it very interesting that each of these companies in their sort of promotional materials would talk about building this casino, which usually is not thought of as really part of a Belt and Road kind of strategy, and a casino in Saipan, part of the United States, which it's sort of unclear what's part of the Belt and Road and not, but if anything is clear, it's probably that the United States is not part of it. Nonetheless, in their promotional materials, talk about this project as part of their contribution to the Belt and Road, right? So MCC on its website, Belton on its website, Gold Mantis on its website, right? Talking about the Idailu. So all of them celebrating this project, and they brought over a large number of Chinese workers on visas. But when the work visas ran out, what they started to do was bring in workers who came on tourist visas and then began to work on the project. And so while Xiaohui described a very simple kind of straightforward system, the reality, like I said, is often much more complex, right? So each company had its share of workers who were there on formal visas, and all the applicable rules that Xiaohui was talking about should apply. But then they would subcontract out some of the work, and those people would recruit workers from China, have them come in as tourists, right, without the proper work authorization, and put them to work on the very same construction site, living in the very same dormitories, often with a similar pay structure and lots of similar problems. And so how does this happen on a very micro level? Often the way that they go and recruit workers is through very informal channels, not these big agencies that are registered with the government, but it could be via WeChat. It could be someone who visits villages and rural communities and says, hey, we have this great opportunity to go work in America and you can make all this money. We were able to find some of the online recruitment advertisements, some of which are, clearly discriminatory in violation of certain Chinese laws, some of which provide information that's simply false, saying that you don't need any sort of visa, right, to work there, that you'll have a 2-year contract. People were promised very high wages. Some were told if they stay in Saipan for a few years, they'll be able to get a green card, all things with no real factual or legal basis. And in light of this exciting opportunity, people paid anywhere from 30 to 40, as high as 70 or 80,000 renminbi, right, which is getting close to 10,000 US dollars, to recruitment brokers in order for the opportunity to go work in Saipan. Oftentimes they don't have the cash to do that, so they could be mortgaging their homes, they could be borrowing from friends, they could be borrowing from a local loan shark. And often there's severe consequences if they are unable to repay those loans. And as you know, the story often goes, despite being promised this sort of great conditions and great opportunities overseas, the reality once they got there was not quite so great. And so, for instance, here's just some pictures of the living conditions, sort of workers crammed together in dormitories, pictures of the bathrooms. One of the first workers that reached out to me had sent me a picture of the food that they were served. So this is kind of like the leftover pancakes that they were served for breakfast. And if you dare look closely, you can see some of the worms crawling on top of them. Sort of a makeshift construction site, no place to sort of formally sit and eat lunch. Just sitting outside amongst the sort of construction debris. Another important piece is that all of the workers, yes, all right, so here's the view, and I can make this available to people afterwards, but here's kind of the online announcements about, the Belton Road on these construction company websites. This was the model I was describing of what it looks like in practice, where you have each company with its visa workers, but then subcontractors who are hiring these workers on tourist visas. This was the online sort of advertisements for positions that we were able to find in Saipan with the false information, like a 2-year contract, and that you don't need a visa to do the job. And then we were looking at some pictures of the housing in the dormitories, bathrooms, the food with the worms, sort of outside at the construction site. Another key, like Xiaohui mentioned, that often happens is the employers will take the passports of the workers, which, often the company has a fairly mundane and innocent, explanation that they want to make sure that they're safe and they don't want people to use them. But the practical effect of not having your passport in your hand is obviously you can't leave if you choose to, or certainly cannot leave without telling the employer and getting their permission, even if the conditions are quite terrible. In Saipan, one thing that was notable was that the health and safety conditions were really atrocious. Almost all of the workers had previously done construction work in China, and almost without fail, they would say that this was the most dangerous construction site that they had ever been on. Even the ER doctors in Saipan started to keep track of all the Chinese workers that were coming in because they were just so blown away by the numbers. And I think in the year 2016, recorded over 80 construction workers who came in with serious injuries. And here are some of the clients that I represent, and just pictures of burnt legs, burnt hands, smashed fingers, that these workers suffered. All of this is in relation to getting paid far less than minimum wage. Even if they were paid, some of the workers that reached out to me had not been paid for 4 months. And so all of these together create a pretty awful situation for this group of Chinese workers. I will sort of speed through the end. Kind of all of it came to a head when a worker who didn't have a proper harness on, fell and died from the scaffolding of the construction site. The companies brought him to the hospital in a SUV, basically. They did not call an ambulance. They ripped off his uniform. They lied about which construction site he was on because he was on a tourist visa. But eventually the FBI figured it out. They came in, they raided the offices of the contractors, found the passports, found the lists of tourist workers, and basically shut down the project. After that, we were able, working with the US Department of Labor and with the workers' own motivation to protest and coordinating with the media, able to achieve a settlement through the Department of Labor that Catherine mentioned, about $14 million for 2,400 Chinese workers. Some of the managers went to jail, prosecuted by the US federal government for employing unauthorized workers. OSHA, which is our health and safety agency, came in and fined these workers. And now I'm engaged in a lawsuit alleging that these companies engaged in human trafficking, as well as are responsible for the injuries that these workers suffered, right? So actually quite a lot of remedies and quite effective remedies for this group of workers. But I think the reality is, in most of the places that Chinese workers are sent, that's not what happens, right? These are often countries that don't have particularly strong rule of law systems or effective labor law enforcement. And so cases like Saipan, I think, are quite emblematic in terms of the problems, but in terms of the fact that they got a resolution and a remedy, are actually quite exceptional. And so this is what led Xiaohui and I to kind of ask the question, well, if you can't get a remedy in the country that you're working, right? So if you're sent to Mongolia or Africa or Southeast Asia and you're not paid or you're injured and you can't get justice through that legal system, do you have any options when you get back to China in practice, right? So Xiaohui kind of described the regulations that exist that should protect workers, at least when they go through the formal channels. And we wanted to see, are those real? And the way we were able to do that is now China, as many of you know, puts all of its judgments, court judgments, into an online database. And so what we did was search for the term, Wai Pai Lao Wu, which basically is one of the many terms used for overseas labor, found about 1,500 cases. Then we saw how many of them even mention these regulations that Xiaohui described, which got us about 583 cases. And then we read through about 100 of them to see, okay, well, if you can't get a remedy overseas and you come back to China and you file a lawsuit and you try to use these regulations to help you, what happens, right? And what does that look like? So hopefully that's a little bit of a cliffhanger, and I will stop there for now.
So I wanted to interject before you get to talking about what you found in your study. I wanted to just throw in a point brought up by my colleague, Professor Jose Alvarez. You mentioned that the workers themselves were quite active. And I'm wondering whether in Saipan or in any of these situations, the worker protest ever kind of coalesced into something like unionization effort. Jose mentions, obviously, the International Labor Organization's commitment to freedom of association and the right to form and join independent labor organizations, something that is not generally recognized within China. But in the Saipan case, for example, with the presence of US law, I'm wondering in particular whether any thought of union representation entered the picture.
Yeah, I mean, so this is obviously a big question even in China, right? About, there's one official state-run union, which many would argue violates kind of the ILO freedom of association standard in terms of how free it really is. In Saipan, I think one of the fundamental problems with overseas workers, right, and migrant workers generally is just that their temporary nature, right? So economically, right, unions, right, are doing a good thing, but need to sort of survive and function as well, right? And so I think in a place like Saipan, where you don't really have a existing union, which is a whole other story, right? It's not easy or obvious who would sort of try to organize and bring in these workers.
Right.
And, with the temporary nature, it's, an organizing drive is often contentious and expensive and difficult. And if they're only going to be there for 3 months, 6 months, 12 months, that's a tough investment. Not to mention, often the union organizers are probably from Saipan, don't necessarily speak Chinese. And you have these hard problems of, one thing I didn't talk about that makes a lot of these overseas situations even more like a kind of forced labor, or sort of smell like forced labor, is you have employers quite actively telling the workers, do not talk to, locals, right? Do not talk to anyone outside the dormitory or outside the workplace. Certainly don't talk to anyone who's a government official, right? Don't complain about anything. And they sort of dangle over their head the fact that they're not there working legally, to say, if you do talk to someone, you're just going to get deported, right? Which is a very effective means of control. So the short answer to the question is, in this case, there was no real organizing drive. I think, like we look at in the United States, where you don't have a union, could you set up some kind of worker center or some kind of, maybe less formal organization or legal aid that can at least provide some assistance to the workers? Might be more practical in some locations.
All right, so let's hear about the study. What did you find when you looked at these cases in China?
So a few things became apparent. One is that in Xiaohui's model, right, where you have, you look at his graphs, you see certainly there's more and more preference for using these agencies, right? Not employers sending workers directly overseas and signing labor contracts, but they like to go through agencies. And every case that we looked at, and correct me if I'm wrong, Xiaohui, they always used a service contract, right? So it's similar to kind of labor relations everywhere, where employers are looking not to put in writing that they are obligated to cover all aspects of what might go wrong, but wherever possible to really try to limit their exposure. And so they sign a service contract that says, we're just agreeing to send you overseas, you'll pay us a fee, and the problem really rests with the foreign employer, right? And so that creates a certain amount of problems, right, in terms of kind of who's ultimately responsible, and that. But I think, we sort of expected to find that, because it's sort of similar to labor relations everywhere, right, where there's sort of a shell game of who's ultimately responsible, and contracts, pointing fingers at different people. What I found surprising was actually the extent to which people were able to use the regulations and get a remedy, though. So there were quite a few cases where, maybe the employer in China tried to point the finger at the foreign employer, and the Chinese court said no. Because this person was recruited in China and only Chinese firms are allowed to recruit Chinese employees, you must be the employer Chinese firm, and you must be responsible for their wages or their injuries. Same thing with the agencies. There are these provisions that say if the foreign employer, doesn't pay the wages or doesn't compensate for work injuries or buy the right insurance, the agency is responsible. And we found quite a number of cases holding the agencies responsible, and also found a bunch of cases that said if the agency is not registered, right, and not doing things appropriately, that they're going to make the agency be responsible, right? So there are definitely some judicial decisions where that's kind of, they get out of it because they weren't registered, right? And the court says, well, I can't apply this regulation to you because you're not sort of part of the system, right? You're not an officially registered agency. But there's other courts that said, look, if you're going to act like an agency, you're going to send workers abroad, we're going to hold you responsible for this full list of things. So I would say those were the more surprising ones. And then the last thing was, I think, the large number of cases dealing with people who went through informal channels, kind of like the Saipan workers, right, who were totally outside of this system, going through brokers who say, give me 20,000 RMB, I'll set you up with a job in Malaysia, I'll set you up with a job in Africa. And that was a large part of the cases.
So I did have one question. I mean, one of the biggest problems in trying to study the significance of legal cases on the ground is you almost never have any information about the cases that don't get brought. So this is probably a teeny percent of the workers who have these problems who actually make it into the system. But in order for a small number of cases to sort of change business practices, either you have a predictable remedy, you're going to get caught, something's going to happen, which probably isn't the case here, or the penalties, the consequences, the remedies are sufficiently strong and onerous that companies realize, hey, even if there's not that big a chance that we'll get caught, but if we do get caught, it's going to cost us. So what happens for the companies that do get caught and the courts do actually pay attention and give the workers a remedy? What does that look like?
Yeah. And Xiaohui, you read the cases more closely than I, if you want to jump in. But I mean, certainly there are cases where, the companies have to pay the wages, they have to pay the injury insurance, but I've never seen any sort of real punitive, right? Here in the United States, sometimes we have liquidated damages, right? When you don't pay wages, you have to pay then twice as much, right? After a court case. I have never seen anything like that where the company is basically worse off than if they would have just paid the wages, at the right time or bought the insurance at the right time. But Xiaohui, maybe you have some thoughts on that.
Yeah, so I think for this question, we should divide, because we say we have two models. For the first model, OPCE model. So it's quite similar than in between, just like in China. We also have such a problem that a lot of migrant workers, they cannot get their pay. So it's similar. So in some cases, we found that some China state-owned company, they always contract in a foreign country. Then when they get the project, they will subcontract to the small contractor. Then the small contractor will sometimes subcontract another contractor. So layer by layer to individuals, then they recruit an employer to the foreign countries. So in some cases, the general contractor, they don't know whether the employee whether they can get enough pay. So the first thing, for the first model, I think, so I think maybe because the illegal subcontractor makes it really happen. And another thing, I think, why they didn't want to sign a labor contract, even the law said in the OPEC model, if you want to send a worker abroad, you should sign labor contract, because as we know, in China, the state-owned company, they have, if you see the Chinese case, we know why they always use the labor dispatched workers, because the wage gap, the informal workers and informal workers, we always have a big wage gap. So for the workers they send to abroad, most workers, they are informal workers. So they don't want to have a labor relationship with the OPEC. So for the next model, we see FLSCE. So just Aaron explained, they always use the service contract because they can make profit from the service fee. Yeah. So why they always do that? So I think maybe the regulation, the punishment is not enough. Maybe because just Aaron said, can they get twice punishment for the pay because they have no contract? Because there are two law systems. One is the labor law system. One is the foreign overseas work system. Whether they can use the labor law or labor contract law. If we read the cases, we will find that the judge in the court are also uncertain on these issues. Sometimes they will just say, okay, you just own his pay, you just you give the pay is enough. Some cases they say, okay, you just enjoy it, you just compensate the injury, so that's enough. They won't say whether they can use the labor contract law. So this may be the next step. I think the Chinese government should make a linkage with the labor contract law and the overseas workers. So, but I think this is also for the question for United States. So if the things happen for the United people, if they work in China, they will enjoy it. So whether can the United States court accept the cases? Can they use the United States laws? So yeah, maybe for Aaron, for Cindy.
I think you're on mute, Cindy. I think you're still on mute. I'll just say for those who are sort of expert on Chinese law, what Xiaohui is talking about with the labor contract law is sort of the main piece of labor legislation that primarily regulates, domestic, right, the domestic labor relations. And so there's this question that we were looking at is, well, if you're signing a labor contract in China to send someone to Papua New Guinea or wherever,
Yes.
Chinese company, a Chinese worker, a Chinese labor contract, do those provisions apply? And I think we found very few cases where they said yes.
Yes.
And in a lot of cases, they either don't address it or say no. But the labor contract law, I would say is not super strong in terms of its penalties and deterrent effect. But at least there's more developed law. There's more regulations explaining the different scenarios. And there are some penalties for like late payment and things like that. But so Xiaohui saying, maybe we can apply that in the foreign context would be a sort of solution, part of a solution.
Right, because from what you're describing, the problems do seem quite parallel to the problems that migrant workers encountered when they first started coming into the major industrial areas. That, after a decade or two, that did result in some reform. And now, we're seeing a rerun in some ways of that dynamic. And yes, there does seem like there's a model there. But, as you say, Aaron, I think there are some provisions of the labor contract law that work pretty well for people who can get lawyers. And it does seem to hurt. It also does seem to have given companies an incentive to try to find escape routes through dispatch workers and the like. But this does make me wonder, first of all, how feasible is it for workers to get a lawyer to even begin, make it into the formal court system? I know that, Aaron, you've worked on this issue among migrant workers generally in China. Is there an extra layer of difficulty for these workers because they're coming from abroad, because the work they did was abroad, or is it just pretty much a replication, another example of the difficulties of workers finding legal representation in China?
Yeah, I think it's probably more a question. Probably more of the same, right? So it's already difficult in China for low-wage workers, right? And if you want to look at it from a sort of comparative U.S. perspective, right, I think at least we've tried to economically incentivize lawyers in the United States to take some of these cases, right? Whether it's through attorney fee shifting that says, even, at least in theory, even if you're bringing a case only worth, $10,000, right? If you have to litigate it for 3 years, you can get paid your attorney's fees based on a market rate for the normal hourly rate that you put into it, right? So it creates an incentive to take a case for something that probably doesn't involve that much money, from a sort of lawyer's business perspective. We also have class actions, right, which are generally just not allowed in China, right? So you have to bring all of these as individual cases, which makes it very time consuming and costly. So I have a report from a few years ago, thanks to Catherine when she was at Ford, that looks at this in the domestic context. And even the ones who get to court, I think, I haven't looked at it that recently, but I think about 40% of workers didn't have any legal representation, even once they get to court, right? That's, already excluding all the people who were told you don't have enough evidence, you don't have a legal claim, you can't find your employer, or another host of reasons, why you might not even bring a case in the first place. So I think all of those problems are exacerbated in the overseas context, right? The evidence problem is huge. I think most lawyers are probably not even sure, do we have a claim if you worked for an employer in Angola, right? And the subcontractor was an Angolan company and they're the one who didn't pay you. Is there really anyone we could sue in China? I think I think what we're seeing that's kind of interesting, and I think an area, at least for me, for further exploration, is what to do about these informal labor brokers, right? Because that adds another kind of layer, and what sort of responsibility do they have, especially if they're the ones who took your money in China, right? And they're the ones who promised you this sort of bill of goods about what a great life you're going to have in, wherever, working on this construction project. So that's an interesting area. I mean, a lot of courts are looking at them just as straight contract cases, right? What did you pay? What were you promised? Was it delivered? But there's also others that are taking a more sort of strict liability approach, which is, these brokers were operating, as if they were formal agencies. Therefore we should hold them to the standard of a formal agency, right? And so they should be responsible for any wages that weren't paid. They should be responsible for any injury that happens. It'll be interesting. And I think, these informal brokers are probably a big part of the problem in the worst cases, right? Because once you push them into informality, it's hard to use any of the remedies that have been set up. So how that plays out, I think, is an interesting question that China at least has been looking into.
So I see we've got some questions piled up, but while I'm looking at those, I wondered, Aaron, if you could just throw in a general perspective, since you also represented workers in the US, mostly workers from China, Chinese-speaking workers in New York City. To what extent were the problems actually similar, and to what extent were they very different? I mean, I think probably most people who are listening would expect it to be dramatically different. I see some parallels. I wonder what you saw this much closer to the ground. What did you see?
Yeah, I guess it depends what you choose to focus on, right? I mean, in terms of a functioning legal system that can give a remedy, comparatively speaking, the US and New York were pretty good in that respect. But I think in terms of the situation that the workers find themselves in, there are a lot of similarities, especially when you start looking at undocumented workers in the United States and start comparing that to, these undocumented workers anywhere else, right? So again, I probably saw a small fraction of workers who were willing to, despite having worked here without a proper visa, right, despite perhaps being afraid of immigration consequences if they came forward, retaliation against their families in China, retaliations against themselves, being in a place where they don't speak the language, don't know the laws, don't have a lot of social capital, don't even really know where to turn to get help. I think that there's a lot of similarities in why those people, it's very, very hard for them to ever come forward and seek help. And it's much more of a mentality of, let me cut my losses, find a new job that's better, if they're able to do that. I think, and we're seeing, I think, more of that in the sort of rest of the Belton Road, right? Where part of the problem, I mean, there's sort of this, I mean, maybe it's ironic in some sense, right? That if you're on a formal work visa, you're tied to that employer, right? In the country abroad. And that creates a big problem, right? Because you can, no matter how bad the conditions are, your only choice are to continue working there or go back to China, right? On some level, once you've sort of taken the illegal route and you don't have a formal visa anyway, and it's sort of like the undocumented workers here, right? You can actually, I don't say can, but you're more willing to leave that employer and find illegal employment somewhere else, right? Because you're sort of, were never legal and never had a proper visa to begin with. So I think, that's often what happens is they move on, they look for another work opportunity. and often the abuse they suffer just never goes addressed.
Mm-hmm. So one question that's come up from the audience is whether Chinese embassies and consulates ever get involved in the protection of overseas Chinese workers when they're overseas.
Xiaohui, do you want to say anything about that, about the embassies?
Yes, I think Chinese embassy always be the first place to protect the overseas workers. So if you see some cases, if we read the cases happened in China, it always say the workers go to embassy for protect. They will protect for their wages. So in some cases, the embassy will ask the employee to get a deal with the worker. Say, okay, so when they will pay the monies and when they will compensation the workers, then the worker can back to China, then sue to the court. So I think the embassy always be the first role to, negotiation with the dispute. But because in the foreign country, they have no, have to deal with the dispute. They only can help workers to negotiate with the employers. Then when they're back to China, in some cases, the embassy will tell the information to the Ministry of the Commerce, say, for some overseas project, they have some illegal things happened. So you shouldn't notice this enterprise. So I think maybe they have take this role. Okay.
Another question is so how do workers even find out that they could possibly get a remedy in China? Are these court cases that you described, did you look or did you find any evidence that they were publicized through the media, through social media? Do workers have a practical way of finding out that it's even possible for them to file a lawsuit and get a remedy once they're back in China?
Yeah, this is a project that I've actually been working on a little bit, more on the side of to what extent does Chinese media discuss the problems that workers have while they're overseas? And, the short answer is not that much, especially when it's sort of a Chinese company abusing Chinese workers abroad. I won't say zero, but there's not that much publicity about it. And there's certainly cases that we read about that you don't really see in the Chinese media. Saipan's a good example because I looked pretty thoroughly to try to see how the Chinese media was describing that. And I saw one story in the Chinese media, and it basically said that, these workers weren't paid. They didn't really get into the other stuff. And that it was all because, the company had entrusted this subcontractor / broker, but then he took away the money and ran away. And so the company, through its goodwill, decided to pay again, basically, right? And they made good to the workers that they got their wages, right? And it makes it seem that the problem is all these bad actors, these unscrupulous brokers who need to be punished, leaving out pretty significant details about criminal prosecutions and violating immigration laws, and the fact that the US Department of Labor had to get involved for quite some time before they made that payment, right? So you get a little bit of a, sweetened story about it. But I think there are cases where now there's a legal aid center in Beijing that formerly focused on domestic migrant workers. They've started a project for overseas workers. And so they'll talk about some of their successful cases. So there is some information out there. And I think, they get calls based on that. I don't know, Xiaohui, if you've looked more closely at the Chinese media and whether you see reports about this.
Okay, I think the media report, yeah, sometimes they will say the administration department, they help the workers to, get how much money when they go to overseas, the workers help the workers. So we seldom to see the news about this kind of workers because maybe, I think most people are focused on the domestic workers. So I didn't see too much media news about it. But once upon a time, I saw news about the Xeban workers. Yes, they do have news in China. But most of the time, I always see the news about gig workers, the platinum firm workers, but seldom with migrant workers. Yeah.
Mm. So when I was doing active research in China, it was a time when there were actually quite a few worker centers operating. And that's one of the main ways that workers found out about what their remedies might be. Sometimes they got legal representation. Some of the worker centers produced educational materials and went out and educated workers about their rights. You just mentioned one in Beijing, and I suspect I know which one it is that's still actively operating, including in this space. But I have the strong impression that the space for worker centers to operate in China has contracted over the last few years, and that would that would sort of tend to close down one of the main avenues that workers might otherwise have. So I wonder if you could say a few words about that.
Yeah, I'll do Xiaohui a favor and take that one. Yeah, I mean, I think it's pretty much uncontested that the space for a lot of civil society groups has narrowed, since kind of Xi came to power. And that's, yes. So that certainly has made, but I think what the government, at least in some areas, has tried to do is, you could say try to replace, right, these functions that were being played by NGOs and nonprofits and sort of non-state actors, and try to have the government sort of come in and fill that void and play that role. And, there's certainly things, and I've written about it, that it's just going to be hard for a government agency to be as flexible and creative. And, certainly if there's a state interest that you're trying to deal with, that's going to be difficult for the government to do. But for instance, in the area of legal aid, there's been tremendous expansion in the number of cases brought for migrant workers domestically, through the formal legal aid system, right, which is run by the Ministry of Justice. They're the ones paying both government employee lawyers as well as private lawyers to do cases. So you can debate about the pros and cons, like I said, of a nonprofit NGO or barefoot lawyer even versus a person who's licensed by the state and depends on the state who's paying them. But, in a lot of cases, maybe it doesn't matter that much, right? And the most important thing is that they're getting representation by someone who, knows how to practice law in that jurisdiction and has a license. So I think, there's things that can happen, right? I mean, right now, MOFCOM, the Ministry of Commerce that oversees this field, technically has a complaint mechanism, but I think it's just very ineffective. And I think they don't do a good job with outreach to workers. It's not really clear that they're processing very many claims or what authority they have to do it other than receive the complaint and call the company, right? But you could see those things being reformed and improved the way that, a Chinese labor inspectorate could be reformed and improved to at least be better at solving some of these problems.
It was also the case that there was talk about the official union at various local levels serving a kind of legal aid function. Has that been sort of fully replaced by this legal aid system that you're talking about, or is that still happening in some places? Does the official union ever get involved on behalf of these workers in finding a remedy?
I haven't seen any explicit cases where it's the union getting involved with these overseas workers, but it also wouldn't shock me if the workers actually sought out the union because they thought they could be helpful, and they said, sure, you're a Chinese worker, we have this established legal aid program, we have to do 200 cases a year regardless, so why not, we'll take your case. But I haven't seen it as an active program of the union to protect overseas workers. But I haven't looked recently. I know, Xiaohui, if you have any idea whether the trade union thinks about overseas Chinese workers.
Okay, so the function of the trade union. So I really didn't see any news about how the trade unions to protect the overseas workers. But we can see that if we see from the notice from the Ministry of Commerce, they will say we should use the trade unions of company to protect this kind of workers. So what's the real function? I for me, honestly, I didn't know about how they play the role. Yeah.
Yeah. So we have a question, a really good question from Susan Finder about whether, so we talked about the inadequacy of the sort of small, not very powerful remedies, but one really big remedy that could be deployed against repeat offenders would be taking away their license to operate. Has that ever happened on the basis of labor violations that you know of?
Yeah, I mean, I'd be curious what Xiaohui thinks. I mean, this is something that's been talked about a lot in the domestic scene of like a blacklisting of companies or removing of their license. And it certainly has happened in the domestic context. I have seen a notice, there is a procedure for doing it for companies that are operating overseas. And it was a long time ago, maybe 5-10 years ago, there was some list that had like 10 to 12 companies that were blacklisted for their overseas projects. But, it's one of these, certainly a drop in the bucket, if that. The question is it strong enough to have a deterrent effect?
Right.
That I just don't know. I mean, I haven't talked to Chinese companies about, are you afraid of your license being taken away? My hunch is they'd probably really say, no, we'll just find another subcontractor to use. And I think that's one of the reasons to subcontract, right, is try to point it on someone else. But I'd be curious, Xiaohui, if you've heard of any hanging down or blacklists for bad practices overseas.
Yeah, I do think the Ministry of Commerce, they say we should have the blacklist, but they still, I think, is constructing. I'm not sure, because according to the regulation, they say that if especially for the foreign labor service corporation enterprise, that if they use, if they have no, if they violate the regulations, they may will be, cancel the license. But for the OPEC, because as we know, the regulation revised in 2017, they just cancel the license for requirement if they want to, if they want to contracting the overseas project. Before 2017, they have a license requirement. But after 2017, for the OPEC, they have no license requirement. But now the requirement only for the Foreign Labor Service Corporation enterprise. But I'm not sure about whether really have happened any enterprise have been canceled the license. But according to law, they maybe have the risk to be canceled. Yeah.
So we've been talking about a number of different possible avenues for Chinese workers to get help. One of them could be, and we have a question about this, whether civil society organizations in the host country have ever stepped forward or become involved in trying to deal with labor violations against Chinese workers. That might be more likely to happen in some countries than other countries, obviously. But for example, I think this relates to a question someone also asked about New Zealand. A country like New Zealand, you might very well expect civil society organizations to step forward and, take some active role in this. What have you, I realize this is not your study, and I do want to get back to your study, but have you seen anything along those lines?
Yeah. It's all anecdotal, but there have been cases of often trade unions, sometimes civil society groups that are able to intervene and try to help. It's not always obvious.
Most of the world, by the way, trade unions are part of civil society, but okay.
Right. Correct. So yeah, there's definitely been instances of it. There's still the question of kind of how do you help, right? And I think, in countries where there is a way to use the domestic legal system, They've tried to do that. There's been a bunch of Australian cases over the but you still have some of these problems of, okay, you can bring a case that might take 8 months, right? The worker visa expires tomorrow or is already expired. So there's a lot of practical difficulties, but it's something I'm looking into now and, getting involved in a project. We're looking at 4 countries, and trying to see the relation, with a domestic trade union presence in some of the industries where Chinese companies are investing, and trying to see, what happens in terms of the trade union's relationship with the Chinese workers and things like that. It's very interesting to put it in a larger context with Belton Road, right? And just sort of like, what is the perception of these Chinese companies, these Chinese workers? And it's a point I tried to make with Jerry Cohen in an op-ed we did a few years ago, which is in the host country, I think quite often, the Chinese workers are viewed as part of the problem, right? It's this invasion of Chinese workers who are taking jobs that should belong to local workers, right? And these Chinese workers are willingly, working long hours for low wages, right? And it's because they don't want to pay the local workers or hire the local workers who are more willing to use the local legal system or seek out a trade union or seek out a civil society group. So it's an interesting question for trade unions of how to think about, and right, is it sort of solidarity with the Chinese workers, or are the Chinese workers the problem? Our point was just to say, these Chinese workers don't really always have it so well themselves, right? They can be quite vulnerable and be suffering, just as much as the local workers sometimes. But that's a dynamic that needs to be unpacked. Yeah.
So one of the very distinctive aspects of the Chinese legal system is the Xinfang system of letters and protests, or I can't remember what the best translation of that is, but it sort of goes back to, pre-revolutionary times, right? So petitioning the emperor, petitioning the leaders. Have you heard of anything along those lines being used? It's a very, it seems to be kind of deeply rooted in the society that you have this option of petitioning to the government. Has that played any role?
I don't know. There's definitely a lot of workers and litigants and complainants throughout all societies, including Chinese society, that will use every avenue available to them to complain and hope that something sticks, right? You'll go to court, you'll go to Xinfang, you'll go to the police station, you'll go to the labor bureau and do everything you can. I haven't heard of like an explicit instance of going to Xinfang and having a result in this scenario, but it's totally possible. I don't know, Xiaohui, have you heard of any Xinfang in this space?
Okay, I also didn't heard about this way to complain, but because most of the time they have a lot of choice, they can go to the arbitration, they can go to court. So I really, because Xinfang case is always very secret, so we cannot saw it in the website, say who go to Xinfang, yeah.
So I like I said, I do want to get back to your study. I have a very specific question, but I wanted to just toss in, you made some mention of this, Aaron, but Ken Wasserman asks whether Saipan is, in what sense does it have anything to do with Belton Road? You said there's sort of at a publicity level, it's sort of part of the initiative, but Belton Road is more than a slogan, I take it. It's got some institutional features. So maybe you could say something about that.
Yeah, that's sort of the $1 million question, right? Is like, now 10 years in, what is Belton Road? And at least from a sort of scholarly policy perspective, you have, I would say, 2 camps. One is Belton Road is a strategy in Beijing for world domination and coordinating state-owned enterprises and sending Chinese people overseas to establish a presence and launching our TV propaganda and building Confucius Institutes, right? And it's all this sort of coordinated effort to, push China's national interests and build China's influence, right? And the other sort of perspective is Belt and Road is like a few words uttered by Xi Jinping. It's a slogan, it's a vision. And now each institution, including even private actors, tries to figure out, okay, like, well, how do I use Belt and Road to my own advantage, right? So maybe I call something Belt and Road, and then I think I'm going to be able to get funding for it. Or, right, I label it as Belt and Road, and then it's easier to get government support, or as an official, right, that, oh, this is not just a road we're building, it's a Belt and Road we're building. And that's going to win you some sort of points. And the truth is probably somewhere in the middle. So I think it's fair to say the Saipan Casino project, and I'll just also say there's no clear list, right, of what is a Belt and Road project and what is not. There's definitely official media reports that talk about some things as Belt and Road, right? But there's no comprehensive sort of list. So yeah, I mean, casinos, things like that, probably are not traditionally what you would think of as Belt and Road. Like I said, Saipan and the United States are not really Belt and Road countries. But I think it's, from everything we've looked at in Belt and Road countries and how these projects happen and are built, I think there's a lot of similarities. And we haven't found much evidence that once something's Belt and Road, that, on the ground, it makes that much difference, right? And you even have projects that were not Belt and Road that started 15 years ago, right, overseas. And then once the Belt and Road was launched, they put the Belt and Road sticker on it. So, we didn't see a fundamental transformation in how the labor relations were conducted once they put that stamp on it. So we haven't found it to make all that much difference on the ground, at least.
So when you mentioned that Belt, I realized that I don't know, what countries are considered Belt and Road countries. Does that include developed countries with, democratic governments and developed legal systems with elaborate worker rights provisions in their own domestic sphere? And does that make any difference? Does the domestic labor regime and how workers are treated domestically make any difference in how they get treated, how overseas Chinese workers get treated by Chinese companies and Chinese contractors?
Yes and no. I think
I'm sorry if I'm asking you these questions you might not possibly be able to answer.
Yeah, there's no simple answer. I think that, so there is a list of Belt and Road countries, right? I think it's basically the country signs an MOU of some sort with China that says we're participating in the Belt and Road, but what exactly the content of that MOU is differs very much by countries. And most of them are not even public or transparent, so we don't know what they say. But yeah, Italy, I think was the first major European country to sort of formally accede to the Belt and Road, and that was big news. And other democracies have certainly joined. I think New Zealand might be part of the Belt and Road. I'm not 100% sure, but there's definitely developed countries that have signed MOUs with China and joined the Belt and Road. So does the domestic scene matter? There's a lot of different pieces of empirical evidence out there, right? You could certainly look at something like the Saipan case and say it doesn't matter, maybe until you get to the point of a remedy, right? That sort of, especially when you're dealing with undocumented workers, the situation is pretty bad. I would say it matters a bit more for the domestic workers, right? And sometimes, it's less clear, that you have these Chinese workers that are sent overseas, right? They sort of try to tell them that the local laws don't really apply to them, or don't think about it in that way, or can't maybe access the institutions to take advantage of those local protections. So probably don't matter as much as for the local workers. But it depends very much on the enterprise. And I think, right, so one thing we want to look at in this next study I'm talking about is you have a Chinese company that goes to these different countries, right? Each has a different legal labor law regime, right? What difference does that make in practice, right? Is that changing the behavior or not? So it's a good question.
And you mentioned that you said the workers are told that they don't have access to the local domestic institutions, courts, labor standards. but I assume that that is not actually true in some countries. Some countries might recognize their labor laws as governing all work that's done in the country, right?
Yeah.
And so this is just, that's misinformation, which may do the trick. It may discourage workers from actually testing that proposition. But I would assume, in the US, if you're in the main territorial US, it doesn't matter who's employing you. You're covered by US labor and employment laws. So is it just misinformation, or are there countries in this category? I suppose maybe the countries that have the least worker-friendly labor institutions might be also the most willing to exclude Chinese or foreign workers working on these projects. But I'm just wondering what you've seen of that.
I mean, I think it's mostly a misinformation problem. Even if you read the Chinese regulations, right? I mean, overseas workers are supposed to go through a training and they're supposed to learn about the laws in the host country.
Oh, really?
Again, once you're outside the formal system, right, none of that happens. And it's a question that I'd like to look into and research is sort of, right, well, how much does it even happen in the formal system, right? What do these trainings really look like? When you're being sent to Ethiopia, like, how many minutes or hours are they spending explaining the Ethiopian labor law to you? And who's even doing that explaining is an interest, and how much do they understand is an interesting question. But I think, I haven't seen actual, written, on paper saying we exclude, foreign workers or something from our domestic labor protections. I think it's more of a practical, sort of law and practice question of, we're not really touching the special economic zone, or, we're not going to really get involved, with what's happening there, or, and I mean, sometimes, right, we've seen cases, I think this was sort of someone's question of, workers in Saipan. It was kind of interesting that they were protesting in the streets and could talk freely to the media, right? That is not the case in a lot of Belt and Road or other countries. And there's been instances, I think in Saudi Arabia, there was a case where, it's always the same, right? It's unpaid workers, right? Boss runs away or doesn't pay them. They're kind of left stranded with no money, start protesting. And there's been a lot of countries where that results in them getting arrested, getting deported, right? Especially if they don't have a work visa to begin with. So it sort of reinforces, why these people might not come forward until it's often too late to really do something about the situation.
Mm-hmm. So one question I had, I'm going back more specifically to your study of these Chinese cases. It's not uncommon in China, it's virtually unheard of in the United States, that it is unheard of, that directives would come down to the courts on how to deal with certain kinds of cases, guidance or directives of some kind. And I'm wondering whether you know of anything that governs these kinds of cases, or is there thinking about, whether there should be some directives, because it sounds like you're getting wildly varied results. There might now be enough cases to make it worth clarifying what are the rules for these cases.
Right. Yeah, and I'll just say, obviously, China is not a common law system, right? So you don't have, for those of you who don't spend a lot of time studying the Chinese legal system, much more in the civil tradition. So it's not so, it happens from time to time, but not so simple as just saying, you're going to go on the database, see how the appeals court decided it, and kind of follow that precedent, right? It's much more directive driven. So Xiaohui, have you seen any guiding cases or regulations or top, sort of decisions on how to decide these cases so that judges know how to decide these cases?
Yeah, I think for the cases we read most, in the second court, the highest, the Supreme Court, we didn't see any cases about how to decide in this kind of works. So for me, I think we do have some guideline. If you see the Chinese government, they always issued some guidelines say we should have to guideline the Chinese enterprise if when they investment in foreign country, how should them to be, I mean, to do good for their workers. But I know, sometimes it's just a notice. The notice is in a very lower, regulation. So for me, I think we still lack from law level to regulate these issues. So just like Aaron said, we're not a common law system. So the cases always change it if you find the cases happen in different province. Yeah. So maybe some judges say, yeah, I agree with you. You should use the labor contract law, but maybe the cases move to another province. They say you cannot use the labor contract law. Yeah.
Yeah. So I think the short answer, I mean, Xiaohui, I think is talking about notices that go to the companies, right? On what are the rules, which, the courts can look to. Mm-hmm. But I haven't seen like a judicial interpretation or a sort of guiding case. I think there are really, like you said, I think we sort of hinted that in the paper it would probably benefit from some more clarity, especially in this area. One of the questions like Xiaohui talked about is to what extent does domestic labor contract law and domestic law generally apply to these workers, and in what situation and which parts of it. Just as a very simple example, if you don't sign a written contract domestically under the labor contract law, right, there's an automatic, you have to pay, I think, I'm already forgetting, like 2 months' wages or something. Right. There's, basically a penalty payment for not doing that. And we haven't really seen that applied overseas when you don't sign a written contract. The other thing I think is on this question of unregistered brokers, right? How should the courts treat this? And I think you have a policy choice, right? You could say it's sort of strict liability and say you want to act as a overseas labor broker when you're not supposed to and you're not registered. You're going to bear the full brunt of all damages, reasonably incurred by the worker. Or some courts actually look at the worker and they say, you know what, you went overseas, you worked on a tourist visa, you should have known, you should have checked the database and know that this is not a licensed broker. And so either tough luck, or we're only going to give you 50% of, what you might be entitled to in wages. And then, like I said, some that just look at it as a contract case of, just an economic relationship of what did I promise you and what did you get, right? So it might be, okay, you paid 30,000 renminbi for a job in Malaysia. You go there, and after a week, right, the job, whatever, the company closes, or for whatever reason you can't continue working there. Or they discover that you're there on a tourist visa and you can't continue working there. So what happens? Is the broker lie? Do they have to give you back the $30,000? And it just becomes sort of a contract question of, well, did they promise you a year of employment, or did they only promise to introduce you to the job? And well, if they promised you a year and you work 6 months, do you get half of your, security deposit back, or do you get nothing back because they did their job and set you up with the work? So there's a lot of variation there that encourages, I think, sort of creative game playing, right, by the brokers, and reasons not to sign contracts and things like that.
Right. Not only creative game playing, but just ignoring the law. It sounds like the chances of getting stuck with any kind of remedy are low enough, so that the message to a lot of these companies is roll the dice, take your chances. You'll probably be fine. You'll probably be able to operate exactly however you want. I mean, that's the concern with, both a tiny number of cases and very small and, remedies that only vary below pretty much the level of what you would have paid if you had complied with the law in the first place.
Right.
So we're getting down to the last couple minutes. So I guess I wanted to give each of you a chance to say anything that you feel like should have come up, didn't come up, anything you want to do to wind up the discussion today.
Xiaohui, do you have any final thoughts?
Okay, yeah, thank you. Thank you for speak. And I think so for the overseas Chinese worker it is not a very hot issues in China, but I think in international, because under the first thing, the next thing I think we should keep focus on the tendency of the overseas Chinese work, because yes, it's a downward trend. But another thing we should know that a lot of Chinese company now they move to use third-party country workers. That means that because the labor cost in Chinese worker is rising, so they would like to use from the Pakistan, from India to recruit the workers, then send to the overseas project. So it's a new thing in China when they do One Belt One Road project. So this thing is also we should keep focus on. So yeah, but I think I saw a lot of questions from the chat room say how we can just compare with these things with international legal mechanism. This is also very important. I think maybe next step, Aaron with me will also can move on these topics. Yeah. Okay, so this is what I thought. Okay. Yeah.
I think I try to be optimistic because I think this is an area where, except for maybe the sort of, unscrupulous employers, could be kind of win-win, right? I think China's image and what they're trying to do through Belt and Road would benefit from, better labor protections for these workers, right? They don't want the strife when they come back home either. I think the regulations are all saying the right things, right? That we should address this problem and better protect these workers. And so I think it's also encouraging, even, MOFCOM, the Ministry of Commerce, in one of their reports was talking about, what's discussed a lot in the sort of like labor migration NGO world, at the UN, at the IOM, ILO, is about like getting rid of recruitment fees, right? That really it should be the employer who pays the recruitment fees, or at a minimum, you shouldn't charge them all up front, right? So that it's so easy to rip someone off to say, give me $30,000 and then it's your problem, right? If you don't pay until you come back from the job, right? I mean, that solves a lot of issues, right? The worker's not in debt from the get-go, right? Not so easy to coerce, not sort of trapped there because they're in debt. And, the labor broker actually has an incentive to make sure that what they promised is delivered. So, I think if China can sort of even be a leader in pushing some of those trends, I think there's talk about an overseas investment law, right? And maybe fleshing out, sort of more rules and more clear guidance about how overseas labor should be handled. What are the linkages with the local labor law? I think it's a interesting problem, a real problem, could be win-win. And so, I think me and Xiaohui and some others, we're going to look at, what kind of practical steps could China take to kind of move the ball forward on this, and hopefully there will be some receptivity there. I think you're on mute, Cindy. Sorry.
Catherine, did you want to say any final words? Yeah, there you are.
Just to thank everybody for what has been a really interesting discussion. I've learned so much. So thank you, Aaron, and Xiaohui. Thank you so much for coming, late at night where you are, to share your research findings with us. And we'll be looking for your next installment of research. And Cindy, thank you so much for leading this wonderful program.
It was a pleasure. Thanks, everybody.
Bye-bye.
Bye-bye.
Thank you, everyone.
Bye.
Bye.